let me really breeze through the public record law. As I said, I really wanted to stress the open meeting law more, but I want to give you just, literally the 5 or 10 minute version of the Access to Public Record Act, just so you know what the issues are and where they might be found. The purpose of the law isn't just to disclose public records, but it's also to protect the privacy interest of persons. There is a balancing test here. We start with the presumption all documents are open unless they fall within one of the 27 exemptions. So, yeah, exactly. And if they don't fall within one of the 27 exemptions, then you get to a balancing test. So there are some exceptions. There are, quite a few exceptions, and the balancing test. Again, you start with public bodies, school departments, school committees. You're subject to the Access to Public Records Act. It's not just records that you created, but it's records that you maintain or keep. So I've had people say, well, we didn't create it. It was sent to us by the police chief. It's their record. No, if you have the record under the Access to Public Records Act, it's subject to inspection by your public body. And this is a law that requires access to documents. It does not require that public bodies or school committees answer questions. So we've had situations where somebody will send a letter, please answer these 35 questions. No, these are not interrogatories. If those questions or that request can be answered through documents, we've said that that's appropriate, but this is not a situation where you have to provide narrative responses. You provide documents, not narrative responses. The exceptions, the 27 of them, again, we're not going to go through them. They are in the book under, you see the citation 38-2-2-4. Again, this isn't, this is just like with the Open Meeting Act. Just because it's exempt doesn't mean you can't provide it. It just means that you don't have to provide it. It's exempt. It still could be provided, subject to the same consideration that Adam brought up earlier, which is that it might be deemed confidential or an invasion of privacy or protected by some other statute. Again, if it's exempt, if it's a public record, we consider it must be disclosed. It has to be disclosed under the law. If it's exempt, that's that middle category. It could be disclosed, but there are documents such as investigative records related to minor crime victims or healthcare records that by law can't be disclosed, and there's actually penalties for doing so. Where if a record, let's just say it's a report that contains the name of somebody that was subject to an investigation, and if that name could be redacted and the document still disclosed without disclosing the identity of that person, well, then the document has to be disclosed. So to the extent that the document could be redacted and the information still provided, then it has to be done so. This is the exception I was just talking about. You'll see cases and our findings in cases from the Supreme Court prior to 2012 that says if a record was identifiable to an individual person, it's exempt from disclosure. That was the way the law read pre-2012. In 2012, it was amended to this current version, which says that to the extent that records are individually identifiable, they're exempt, but only where disclosure would constitute a clearly unwarranted invasion of personal privacy. So there's this balancing test there. Exemption M, correspondence to or from elected officials in their official capacity. Those are exempt from disclosure. Again, it doesn't mean you can't provide them. It just means you don't have to provide them. They're exempt. Some of the other exemptions, and again, we're not going to go through all of them. The investigatory records of public bodies, those are exempt, except for records of final action. To the extent that something might not be exempt under the Access to Public Records Act, but it's deemed confidential in some other state law, federal law, court order, it's incorporated into the Access to Public Records Act. This is the question that somebody had mentioned earlier about executive session minutes, any minutes of a meeting of a public body which are not required to be disclosed pursuant to the pursuant to the Open Meeting Act. Those are exempt. Those are properly sealed executive session minutes. And then these two were amendments from 2013. Documents prepared by school districts that are intended to be used by school districts to protect the safety of their students from potential and actual threats, those are exempt. And any individual identifiable evaluations of public school teachers made pursuant to state or federal law, those are exempt from disclosure. Your school committees, your school departments have to have procedures for the public to access public records. They have to be available on the school district's website. They have to be in writing. I'm hopeful, I'm fairly certain that all of you do have written procedures, that they are posted, but you may want to just check that out. Your procedures have to include, at a minimum, the identification of a public record officer, how the public can make a request, and where they can make a request. And there's no requirement that that the public make a request on a specific form, as long as the request is readily identifiable as a request under the Access to Public Records Act. And as I said, a copy of the procedures have to be on your website if one is maintained, and a copy has to be otherwise readily available to the public. This is probably the most, first of all, having that process is really the most important thing, not just for the public, but probably for you also, because you may be getting these requests personally. You need to know what the process is for the public to make requests, so that if a request is made to you, that the request gets to its proper place. So make sure you know what that request is, how those requests are handled. It's particularly important because of this requirement that when a request is made, the public body has to do something within 10 business days. You either have to provide the documents within 10 business days, you have to provide a denial within 10 business days, or you have to extend the time in writing for good cause within 10 business days. So one of those things has to be done. If it doesn't happen within that time frame, it's a violation of the Access to Public Records Act. And then we'll go through these pretty quickly, but the denial has to be in writing, state the specific reason for the denial, and indicate the procedure for an appeal, which is to file a complaint with the AG's office, to file a lawsuit in Superior Court, or to file an appeal with your chief administrative officer. And there's no requirement that anybody actually fulfill all of those in order. They can go right to Superior Court, right to the AG's office, whatever they might choose. The procedures prior to providing records, it used to be that you had to provide an estimate before you provided the records. That's no longer the requirement. That's only a requirement now upon request. And the search and retrieval has to be done in a reasonable period of time. If you're going to extend the time for good cause, it has to be done in writing, and it has to be specific to that particular request. It can't just be some boilerplate language, and it has to be for one of these reasons: because of the voluminous nature of the request, the number of the requests pending, or the difficulty in searching for and retrieving or copying public records.
The time frames that you mentioned in which we have to respond, that's only to a request that's been made following the policies and procedures that are set, right? If I see Adam on the street corner and say, hey, can you guys get me a copy of this, that, or the other, we're not starting any clocks at that point. It's only when the official request is made per the policy, correct?
So the answer is yes. And we have findings, and this is why it's so important to have these procedures, not just to let the public know, but for your own protection. If you don't have procedures, we have found basically in the situation that you're talking about, where a member of the public was at a meeting and asked the committee for a document, we found that that was a valid public record request because that public body had no procedures. So there was no way to say that that was improper. If you have procedures and the procedures are X, Y, and Z, and make the request to the office of the superintendent, but Adam gets a request, well, then that's not a valid request. Now, in the interest of everybody, Adam may want to say, hey, I've gotten this public record request, I'm going to hand it to the superintendent, and the clock would presumably start when the superintendent gets it, rather than just throwing it out and saying, well, it's not a valid public record request. Because if that's what happens and Adam just throws it out, well, we're still going to get a complaint, the public body's still going to have to respond to it, and it may at the end of the day not be a violation, but everybody's still going to put in time and effort. You may very well get press that it's bad, complaint filed against whatever committee, and that can be solved. If somebody who's in Adam's position just takes a step and either directs that person to what the proper procedure is, or forwards that request. You can't deny records based on who's making them or based on the reason for the request, or ask for specifically identifiable information for somebody making a request. The cost, there is a cost that you may charge for access to records, 15 cents per page, $15 per hour for search and retrieval, with the first hour being free, and no more than the reasonable actual cost for providing electronic records. The time it takes you to review a record or redact a record, that's part of the search and retrieval time. And your public body can request prepayment for records. So if there's a voluminous request that's been made, you can require, based on an estimate, a reasonable estimate, what that cost will be and require prepayment. Members of the public can request that a document be delivered to them in a specific manner, whether it's by fax or email. You have to honor that request. If there's no cost associated with that, the member of the public can be charged that. There may very well not be a cost associated with that, the way electronic email is and faxes and all that. If somebody makes multiple requests of your public body within 30 business days, within a 30-day time frame, that request, rather than getting 1 hour free for each request, you can group all of those requests together and provide 1 hour free for all of those requests, provided that it's from the same person or organization. There was a question earlier about trying to compile documents for an access to public record request. There's no requirement to do so. There's no requirement that a public body reorganize, create, or consolidate documents that the public body does not have. The exception is if they are in an electronic format and the public body would not be unduly burdened in that scenario. Okay, but otherwise there's no requirement to create documents. Talked about that. Whoever your designated public record officer is, they have to receive training from us annually. They have to submit that in a certification form to us. And again, the penalties, we talked about $1,000 for a reckless fine and $2,000 for a willful unknowing. And I promised Tim I would get you back to 10:45 right on the dot.